Hi, everyone. Welcome back to the So Stipulated podcast, your legal podcast. I'm Alexis Gamliel, a plaintiff's employment and personal injury attorney based right here in Los Angeles, California. And I'm accompanied by my co-host and dear friend.
Hi, everyone. I'm Gabrielle Gordon, the So Stipulated co-host, and I'm an employment defense attorney here in Los Angeles, California.
And Gabrielle and I are so thrilled to bring you this episode today about a crucial and very important and serious topic. Today, we are going to talk about sexual harassment cases. And these types of cases form part of the bread and butter of my practice as a plaintiff's employment attorney here in LA. So Gabrielle is going to begin us with the discussion because one thing among many that I admire about Gabrielle is that she provides advice and counsel to employers. And as a plaintiff's employment attorney, that's something that I appreciate. Why? Because you are the person who's teaching and instructing employers how to not engage in the conduct that is wrongful that we're going to be here to discuss today. So thank you, first and foremost, for doing that, because you're actually advocating for the plaintiff side, even if you don't realize it.
I appreciate that. And I think that it's important for us to recognize that a workplace free from harassment creates a better environment for everyone. You have happier employees. You have employers who are not burdened by lawsuits or complaints. So when it serves everyone, and it's in everyone's best interest to have a workplace free from harassment. And so I really enjoy this part of my job and giving advice and counsel to employers on how to ensure, first, that their workplaces do not have harassment. And if harassment is happening in the workplace, what they can do, what steps that they need to take to ensure that harassment isn't occurring any longer, or how to remedy if there's, a bad apple. And oftentimes that does happen. So harassment, I think that term is thrown around a lot. And what people don't realize is that there's actually a legal definition to the term harassment. So I'm just going to pull out my notes and make sure we get this legal definition correct here. But harassment is severe or pervasive, unwelcome conduct because of sex or another protected category, which we'll talk about in another episode, that has an adverse impact on the work environment. And the standard that we're looking at to determine if it's harassment is, what would a reasonable person think? There's a lot of talk about the reasonable person. So a reasonable person standing in the shoes of the victim or the employee who's experiencing that conduct.
Gabrielle, you're absolutely right. There is a very specific and narrow legal definition of harassment. And there are various types of harassment, whether it's on the basis of sex or gender, which is the main subject area that we're going to discuss today. But there's also harassment on the basis of race, on the basis of age, religion, and other protected classes. But for our purposes here today, we're focusing on a very specific subset of that harassment. And it takes different forms, like you said. It can take the form of verbal harassment, physical, and a variety of other different types. So how do you, as a defense attorney, start when you're going to various companies, your clients, and you are tasked with giving them a sexual harassment training? Because, by the way, under a specific California government code section, it's mandated for certain types of companies and businesses of certain sizes to meet this requirement of having that sexual harassment training on a periodic basis, right?
Yes. So what I do is kind of what I did just now, which is define harassment, because a lot of people don't really understand what it is, and that it's based on one of those protected characteristics. And so there is a difference between someone who is kind of an equal opportunity, well, I'll use the word jerk, someone who's not kind to people, but it's not based on any protected characteristic. They're not just discriminating based on, or their behavior is not based on someone's race or their gender or their age or some other protected characteristic. That person is just unkind to everyone, and that doesn't fall under the legal definition of harassment. Now, also, though, it's important to note that that person who is jerk of the company, there may be policies, and oftentimes there should be policies against that kind of behavior in employee handbooks. So the company may have a specific policy based on that kind of behavior, but it actually doesn't fall under the legal definition of harassment. And so that's a really good place to start in terms of understanding what behavior is actually prohibited and what is a policy violation of the company.
And maybe we can pause on that point right there, because I want to punctuate this, that there's a difference between the policies and procedures of a company and what California law requires, right? So in your role as an employment defense attorney, do you help your clients craft these policies and procedures that say certain conduct is inappropriate or not allowed, and if you do these things, you will suffer the consequences up to and including termination?
Yes, absolutely. I think that having really strong guidelines for companies is what's really going to protect everyone actually at the company. So it's not just protecting the employers, it's also protecting the employees. They understand what conduct is permissible, what conduct is not permissible, and what's going to happen if they violate this company's policies. And like you said, termination is possible. Let's say they're violating these company policies on multiple occasions. There's a lot of verbal warnings first, then there's written warnings. But I think that having these policies clearly laid out, it protects everyone because it ensures that everyone is very clear on what is permitted and what is not permitted in that company setting.
Well, they should be in an ideal world, right? And that doesn't always happen. And that's where I come in and have to assert these claims on behalf of people who have been crossed and wronged and sexually harassed in the workplace. Let's talk about some examples, because it's really easy for us, even as attorneys, to fall back into talking about these broad strokes and what harassment is and what it means and all that. But what are some examples of things that you have seen in your practice of claims that you've had to defend, and how can you actually tell what is going on within the company and what your clients are telling you or not telling you?
So there's two types of harassment that we'll talk about today, and we'll start with quid pro quo harassment, and that means something for something.
And that's a Latin phrase, right?
That is a Latin phrase. Lawyers use a lot of those. So quid pro quo essentially is something for something. So it's kind of, you do this for me and I'll do this for you. And so we see a lot of examples of this. I'm sure you have cases with this, but I'll give an example that I think our audience members will all be familiar with. If you've seen the movie Legally Blonde, there's the elevator scene with Elle Woods and her professor. And he makes it very clear that if she behaves in a sexual manner with him, then he's going to elevate her career. So that's an example of something for something. And we see that also in cases of with, let's say, a supervisor and employee. You do this sexual act with me, I will give you a promotion. That's an example of quid pro quo harassment.
Yeah, and the law provides against that. And a woman or anybody in the workplace shouldn't have to engage in conduct of a sexual nature that they do not want to engage in, on the basis that if they don't comply, that their career is going to be compromised in some way. Obviously, I think, and a lot of people must agree, that there's something fundamentally wrong with that. And that's why California law is what it is. And yeah, notwithstanding the law, we still see it, unfortunately, even today. And even today, as our society becomes more progressive, especially in California, I think it's important to recognize that this still is a widespread phenomenon. And that's why I have the job that I have. And it is with great pride that I combat these issues. And so some of the examples that I've come across are where, a sexual harasser is approaching my client, the victim, in the workplace, and they say, I need you to come and go on a date with me. I want to go on a dinner date to discuss business. That's what they say. And then really it's turning out to be more of a romantic situation. And then they're approached again and again and again to go and have dinner with Mr. Bossman. And my client is then afraid to say no, because if she does, what happens? What's the consequence? This person is their direct supervisor, their boss, the head of the company even. So there is something extremely egregious and unfair about that, because a woman or any person in the workplace should not have their advancement hinge on whether or not they submit to sexual favors or romantic gestures.
Which is exactly why this quid pro quo harassment is so important, that we understand what it looks like and that employees understand what that means. And the example that you just gave, which is going out to dinner, the boss is not saying, if you go out to dinner with me, I'm going to give you a raise, or I'm going to promote you, or you're going to have these certain types of benefits at the company. It's implied.
Right. From the power structure.
Exactly. So it's implied, and there's an uneven power structure. You have an employee and a supervisor. And so it's important to understand what that looks like, and also for the employer to understand what making those types of comments is going to look like and appear as. Because an important thing about harassment is that it's not always intentional. And so I think that with an education,
sometimes it is. But yes, in situations where they don't even mean okay, or if they say they don't mean for it to be sexually harassing or even harassing at all.
I do like to give people the benefit of the doubt that sometimes that they really truly do not know that their conduct may be considered harassing. And so that's why this education and these trainings mandated by California law and that I provide are so important, so that employers can really understand how is their behavior being perceived and is it in fact harassing? And if they didn't mean it, then they need to not engage in those types of comments and those types of behavior. And I think it's interesting that what different generations may view as harassing comments or statements. We're millennials. I think that we have a different view of what comments are acceptable just based on society that we grew up in and how we view the world than someone who's in the boomer generation or even Gen Z below us. I think that we all have different views of what comments are acceptable. And so that's where that the part of whether this is intentional or unintentional comes into play. And a good person, when they're being told that their behavior is unacceptable, they're apologetic and they don't want to be a harasser.
And ideally, they adjust their behavior and don't do it anymore. But the other thing that I want to mention is something that we discussed earlier, which is that it's in large part about how it lands on the sexual harassment victim. And it's not just about what the harasser thinks is acceptable or unacceptable, because help us all if that's the determining factor.
Well, the standard really is a reasonable person, right? That's the determining factor.
Right.
So a reasonable person in the shoes of the victim, what would they think? And I'd like to add to that point that it's not even just the victim. If there's a third party witnessing that behavior, what is that third party, that other coworker, that other employee, or even another supervisor, what do they perceive of that behavior? We're going to assume that's the reasonable person.
Right. And it calls into question, I think it's part of it is like it poses an existential threat to the person observing it. Like, let's say I'm a woman, I'm a waitress or a server in a restaurant, and let's say I'm working as a server in a restaurant, and I see all of my female counterparts getting harassed, whether they're grabbed or the male supervisors are commenting on their physical appearance in a certain way, and it's entirely inappropriate. What am I supposed to think and feel? I'm then afraid and in a state of just trying to navigate the situation and dodge bullets as I go through my day-to-day work. And that is where it becomes intimidating, hostile, oppressive, and all of the magic words that are part of the California civil jury instructions on these issues. And so that goes back to, how do I prepare and analyze a case when I'm confronted with a sexual harassment case in my practice and someone calls or they send me an email and they say, hey, I think, or not I think, but I know this is happening to me and I want to talk to somebody about it. The first thing that I do, and the lens through which I view these situations, as we talked about before, is I aim for the target in all of my cases. What does that mean? That means I'm looking at the jury instructions, because that's the end game. When you're a trial lawyer and you prepare your cases from the beginning for that end point of trial, is looking at the jury instructions, and those are the guiding principles, those are the literal instructions that the jury gets and they take back to the jury room. And if the case has been proven and all of the elements are checked off, that's what the jury does, is they answer yes or no. Has the plaintiff checked each and every box of the elements?
And I want to add also, because I've been talking a lot about the reasonable person today, we view the jury as the reasonable person. So when a jury is hearing the facts or what the plaintiff is alleging happened at the work environment, the jury is the one analyzing those facts. And is that jury, who's supposed to be a reasonable person, how would they feel had that conduct happened to them or happened to a loved one? And so it's important to view these cases from the lens of how the jury is going to perceive these facts. And what's difficult often about these sexual harassment cases and harassment cases in general, whatever protected category that we're speaking of, be it age or race, etc. What's difficult about these cases is often it's he said, she said, a he said, a she said, she said, meaning that there's no witnesses to what happened. There's no witnesses to the conduct that's being alleged. And so what's really difficult is the person who's most credible is the person that the jury is going to believe, because that's who the reasonable person is going to believe. And so it's difficult when you don't have any any proof. You don't have video recordings. You don't have any witnesses of what happened. Yeah. So I think we go back.
Except for the testimonial evidence of the depositions or the in-trial testimony of each of the people. And like you said, it can and often does go back to credibility.
I think that might also be challenging too when you look at the issue of credibility, because that may mean that the person who's well-spoken or better spoken is able to win the case. And that doesn't necessarily mean that the person who appears more credible is actually more credible.
Let's talk about the different forms of sexual harassment. I loved our conversation before we sat down in these chairs and how we went through a few different examples, and it can take a lot of different forms, as we referenced earlier, verbal, physical, and other. And you brought up a really great example that people don't often think about when it comes to sexual harassment.
Absolutely.
What was that?
Let's get into hostile environment sexual harassment. Again, a legal definition that I'm going to provide to you guys. So hostile environment is sexual harassment that has the purpose or effect of unreasonably interfering with work performance and creates an abusive, hostile, or offensive work environment. So again, like we were saying with these words, they're legal terms of art that we need to really be able to prove all of the elements. And that's where the conversation of the jury instructions come in, is that these legal claims have elements that we need to prove. And so in hostile work environment harassment situations, there's a lot of ways that an environment can be seen as hostile. So some of those examples, we have verbal conduct, and let's get into examples of all of these. So verbal conduct.
So inappropriate jokes, commenting on a woman's breasts, for example, commenting on a woman's legs repeatedly, or even once. It depends on whether it's severe and or pervasive, and that is something that the jury ultimately determines at the end of a case like this.
Right. So severe is really how bad is that conduct, and pervasive is how often is that conduct occurring. So those are questions.
Does it pervade the work experience? Is it overwhelming? Is it too frequent? And the severe, what is severe to one person may not be severe, or maybe even more severe to another person. So that is at least in part a subjective standard.
Well, I'm sure you're also going to laugh because I'm coming back to the reasonable person again, but would the reasonable person view that conduct as severe? What's also interesting is what is severe? For example, is touching someone's breast one time considered severe? And is that on the same level?
I would argue yes, and under any and all circumstances, because a woman's body autonomy is central to many of these cases. And so I would say yes.
Well, your clients are lucky to have you as that advocate. But I point out that example as severe because on the other end of the scale, conduct that would be considered so severe is if a rape occurred at the workplace. And that's something that we have to take very seriously.
Or at a work event.
That's another great point, is that the
holiday parties are notorious for these types of conduct.
Absolutely. Yeah. What's interesting is the work environment. I think people think that it's just the office, the place that you go into work, but actually the workplace it could be outside. It could be at a restaurant. If you're at an event with all your colleagues, that restaurant has now become the workplace. If you're at the Dodger game, let's say, with all your colleagues, and something inappropriate happens in the bathroom of that Dodger game, well, now that's considered the workplace.
And let's talk about remote work and how this has translated into video conferencing. Maybe the chat has become inappropriate. Maybe Slack messages have become inappropriate. I've had many cases, especially since my practice has heated up in the course of the pandemic and post-pandemic. Many of the messages and sexual harassment instances that I've seen have even been remote. And when you're messaging, or I shouldn't say when you are, because Gabrielle, you would never.
I'm telling employees, please don't message on Slack, on whatever program you're using. I mean, your employer can read those. Please don't send any lewd messages to
Please don't, because it's bad to do in the first place, but also please don't from your perspective, because it will be discovered, and I will discover all of it.
You would not be doing your job if you didn't ask for those documents and for any evidence of Microsoft Teams. And so if anyone's listening to this podcast, just be very careful what kind of things you're texting your coworkers and what you're putting in those Team or WebEx or whatever platform you're using those messages, because you're right that the remote workplace has really expanded what our definition is of the workplace. So before it was a smaller scale, it was people
the
would
four
go into
corners
the office,
of the office.
Right. Yeah. And now it's expanded into this giant thing where it can be a chat. It can be what's on your screen. It could even be what you're wearing if your clothing is inappropriate on a Zoom meeting, let's say.
Right. Or yeah, and an example of that would be an inappropriate phrase on your t-shirt that somebody else is seeing and takes offense to. And similarly, sexual harassment can also be visual. Like you said, it could be a drawing, it could be a variety of different things. And what I would say to any employees listening to this is, if something in your gut tells you that something is wrong, there probably is something very wrong. And so it's worth having a legal consultation over these issues. And the law and the language of the law can seem a little bit complex and inapproachable at times, but it all comes down to common sense, really. Is it overwhelming? Is it intimidating and hostile? And is it all about your sex and gender? Or is it something else?
Yeah. And I would say that is a good way to, as a first step, really, is this wrong in my gut? Truthfully, if it looks like a duck and it walks like a duck, it's probably a duck. So if you really feel that this conduct is inappropriate, whether you're witnessing it or whether you're experiencing it yourself, I absolutely agree with you. And that person should call you or another plaintiff's lawyer and to discuss what is occurring in the workplace. Or really, these employers have policies in place. And so there is a reporting structure. There absolutely should be. I always advise my clients to ensure that that employees know who to go to in HR if they're experiencing conduct that's inappropriate, because the company wants to ensure that the employee is not experiencing that conduct and that there's no harassment in the workplace. And so steps will be taken once that employee reports conduct to the proper person. And when I say steps taken, I mean employees you're not going to be retaliated against, which is against the law, but you should report the conduct so that it can be investigated and that you can be protected.
Well, yeah. I mean, the law says that employees cannot be retaliated against if they report sexual harassment, but we all know that laws get violated every day. And unfortunately, that is the case. And that's where you should not have a fear of retribution for reporting sexual harassment. But that is also actionable conduct if your employer does do that. And so that's a whole other separate cause of action, and absolutely an episode for another day, because there's a lot to unpack there, where you cannot punish someone for reporting conduct that is illegal or in good faith is believed to be illegal. And we'll talk.
Co-sign that, and we will absolutely get into retaliation on another episode. So stay tuned for that.
And by the way, but just high level, the reason why there is that anti-retaliation law is because you want to have these laws have meaning, and you want to be able to protect people for helping you as the employer enforce those laws.
Yeah, definitely. Let's talk about some other forms of what could create a hostile work environment, just so anyone who's listening to this episode or watching us can know what kind of conduct may not be acceptable in the workplace. So some conduct that's pretty obvious is, I'll give an example of if there's an inappropriate text message with sexual undertones. That would be an example.
Or overtones.
Overtones.
All of the above.
Both.
Unacceptable.
Yes.
All of
unacceptable. What they call sexting. So that would be an inappropriate text message that would create or could create a hostile work environment. I would say would create. If I had a case where this was a supervisor who was showing photos of his significant other to other employees, and sexual photos, to clarify. And so that would create a hostile work environment. Do you have any examples of visual conduct that you've seen in your cases?
Visual conduct, I would say inappropriate drawings, like I referenced earlier. I could describe them in detail, but I will spare all of us that description.
Other conduct could be actually physical itself. So hugging, depending on if that person doesn't want to be hugged, grabbing or groping body parts, kissing. And also an interesting example, and to circle back what you and I were talking about, is giving gifts and unwanted receiving of gifts.
Yeah, this is one that doesn't come up as frequently, at least for me. I haven't seen it that often in my practice, which is good. But I was really curious to know about what you have seen in yours on this note.
Yes, because look, giving someone a gift for the end of the year, for the holidays, that's not what I mean by unwanted gifts. An example of this in a case that I use in examples in these harassment trainings is that there was a situation where a supervisor was giving an employee a Hershey's Kiss, the chocolate, and leaving it on her desk every day. And that was unwanted conduct, and that was creating this hostile environment for her. It was uncomfortable. It was unwanted. She felt
there was something romantic about it.
Right. The insinuation of what a Hershey's Kiss is also.
Yeah.
And so
it has to do with both the nature of the gift, like it's a kiss. That's why there's a suggestion there. And then also the frequency every day is overwhelming, and it becomes pervasive at that point.
Yes, definitely. And also because it's a Hershey's Kiss, it's interesting because if someone were to ask me, well, is it not acceptable to give a box of chocolates to an employee who's doing a good job? It's always a fact-specific inquiry, and I would say it depends, but a box of chocolates is probably not problematic. Now, is it Valentine's Day and a heart-shaped box of chocolates? That might be a different story.
Then the nature of the gift changes.
Right.
Right.
So I think that it's important, and what we want to emphasize here today is that it's always fact-specific, and it's what would a reasonable person think. So always go back to what would a reasonable person think standing in the shoes of the victim.
Right. And another example that we've talked about before too is compliments. There's a difference between, oh, I like your dress, and you look hot in that dress. There is a line that needs to be drawn, and especially when these comments are coming from the supervisor to an employee, unacceptable.
Absolutely. And I also want to point out the way that your tone shifted when you were giving those examples. And so employees, supervisors, employers, everyone should be cognizant and hear how they're speaking and hear how that compliment might be construed, because there's a way to say something that's a genuine compliment that wouldn't be creating a hostile environment. And then there's also a manner of speaking to someone which is completely inappropriate and unacceptable for the workplace. And so the way you said those two lines, I think, is really important to just point out and emphasize that.
Yeah, there's an absolute distinction there. And the line between professional and unprofessional is an important one.
Definitely. And I think that those lines can get blurred, and that's what's difficult for employees. If it's a supervisor and an employee, we have a power imbalance. And so the line is not as easy to blur. But when you have two coworkers who are friends who speak to each other in one way, it might be acceptable to say certain things to a friend that would not be acceptable to say to someone else. And so it really depends on how that comment is being received by the person receiving it to determine if that would create a hostile environment. So it's really totality of circumstances.
Right. And this reminds me of a point that I wanted to make is in one of my very favorite California Government Code sections, section 12923. Yes, I actually do have a favorite government code section.
That makes one of us.
Yeah. In this section, there's reference to that it doesn't matter what industry or type of workplace we're talking about, the same legal standards apply. So if we're talking about restaurants, let's say, or the hospitality industry, but let's focus on restaurants. Historically, this industry may have had a greater reputation for sexual harassment and conduct that we now call out as sexual harassment, whether it's comments, physical conduct, inappropriate gifts, what have you. It doesn't matter if we're talking about a restaurant versus a finance firm, the same legal standard applies. So we're not going to just let things fly because it's a restaurant or because it's some other type of work environment that has historically had more of that conduct. It does not matter. We are all held to the same standard here in California.
And I want to emphasize that the industry does not matter. And it's really important because there are cases out in the news of law firms that even employment law firms that those are the attorneys who really know these laws that are defending clients against these claims. And there have been allegations against them harassing their employees. So the point we're trying to make here is that absolutely nobody is exempt from these rules.
And no one's above the law.
No one is above the law. We're all held to a standard of how we need to conduct ourselves at work, or we and you will face the consequences.
And to that I say, so stipulated.
So stipulated. All podcast episodes provide general information and do not constitute legal advice to any person with respect to any circumstance. This podcast does not create an attorney-client relationship with any person. All opinions reflected are our own. Don't forget to follow us on Instagram @SoStipulated. Thank you.